A survey reveals a great deal about a property. Some things may be obvious while others may not. Simply put, a survey shows the property boundary lines and where the other improvements may be located on the property being purchased. There are several reasons why someone purchasing a property should obtain a new survey. Here are some of the most important reasons. This includes whether the improvements are located in the boundary lines, whether any neighbors are encroaching on the property, whether there are any county setback violations, any association restrictions, and whether or not any easements may affect legal title to the property. This is important because anyone purchasing property wants to ensure that their property does not violate any setback issues, is not located on an easement, and is actually situated on the property being purchased. The same holds true for pools, sheds, AC pads, driveways, fences, and a whole other laundry list of potential improvements. If the improvements are not properly situated, then in a worst-case scenario, they can be subject to removal. Additionally, if you plan to make improvements on your property in the future, you will end up needing a new survey for permitting requirements. One cannot assume that because the parcel is located next to a road or a waterway that one automatically has legal access. Only a survey can verify legal access to a property. Also, your title insurance policy will not cover any title defects that would have been disclosed if you would have obtained a survey. For example, if you close on a property without obtaining a survey and you later down the road find out that there is a building setback violation, you will be responsible for obtaining a variance or bringing the building into compliance, which may be very costly. Often, buyers may request to use a seller's prior survey when purchasing real estate. However, one can only rely on the prior survey if the seller has an existing survey that accurately depicts the current state of the property, and the seller is willing and able to sign an affidavit at closing that there have been no changes made to the property since the date of the survey. When relying on a seller's prior survey, please remember the survey is certified to the seller, not the buyer, which means in the event that there is a mistake made by the surveyor, the buyer has no recourse to go to the surveyor and get the mistake corrected. Additionally, since the seller's prior survey does not fit in the definition granted in the FAR bar contract, a buyer may not object to a seller's prior survey. Therefore, if an encroachment issue arises on a survey, a buyer will have to purchase a brand new survey in order to object to that title issue. When selecting your surveyor, please ensure that your surveyor has liability insurance and does not limit his or her liability to the cost of the survey. The survey should be certified to you, your lender, the title company, and your closing agent. Upon receipt of your survey, consult with a local real estate attorney to see if there are any survey defects that need to be objected to. Ideally, you want any setback issue, encroachment issue, or any other survey defect to be the seller's responsibility for them to remedy prior to closing. As a buyer, you don't want it to be your responsibility when you go to sell or refinance your property in the future. When purchasing property, paying a few $100s for a new survey is a small price to pay. I'm Mallory Moretti, and I hope this helps.